So, this evening we are lucky enough to be joined by our wonderful panelists, Mooting, Isabel Ryan, and Monique Pitt. They are truly some of the best mooters this university has ever seen. We're incredibly grateful that they've chosen to dedicate their time to us this evening. So we'll kick things off with a brief round of introductions. We'll just get each of the panelists to go over their involvement in mooting and what they're up to now briefly. So Monique and Isabel, do you want to kick things off?
Yeah. Hi everyone. So yeah, I'm Monique, and I started getting involved in mooting when I did the first year moot. Fortunate enough to have a great experience through that and met some people in the Mooting Society. And then I was on the exec of the Mooting Society from my second year to my fourth year when I was co-president with Isabel. And in that time, I also competed in pretty much all of the available moots, either with Isabel or on my own. And yeah, my last one was Stout Shield last year. But that's sort of my time at mooting at law school. And now I'm working at the Auckland High Court as a judge's clerk.
Yep. Hi everyone, I'm Isabel. My mooting experience is very similar, if not identical, to Monique, with the exception that I did Stout in 2020 and 2021, 2022. I did Stout the year before Monique, whichever year that was. And I was involved in coaching and judging, and then in 2021 was the co-president of the Mooting Society with Monique, and have just been involved ever since the first year moot.
Hi, I'm Iru, and I had a slightly different experience to Monique and Isabel in that I didn't actually start mooting till my fourth year of uni. So it's kind of weird that I'm here. No, I mean, like, just in some senses, like a lot of the time I was just like watching Monique and Isabel like moot over and over in order to learn mooting. So yeah. I am still in uni. I am also Andrew's co-development officer this year. So I will hopefully be seeing more of you at these events. The last one, yeah, I did quite a few moots. I did international humanitarian law moot. That was my last one. I was doing Stout in the same year as Monique, so I can confirm that was 2022. I've also done like John Haig and just a few other little ones.
Please, thanks for that. As you can see, they're all very accomplished mooters on their own right. So I'm just going to give a brief outline of how this workshop's going to run. We'll run through four main topics. Firstly, reading and analyzing the moot problem. Secondly, researching and forming an argument. Thirdly, your written submissions. And fourth and finally, oral submissions. So without further ado, we'll get straight into it with reading and analyzing the moot problem. And I'll direct this first question at Monique and Isabel. What are your tips when you first get the moot problem for reading it and analyzing it, and in particular identifying contentious issues?
I guess one of the first things that's always going to happen when you get the moot problem is you're going to be a bit anxious and overwhelmed when you first read through it. So I think it's my tip would be the first time you read it through, it's not really to get everything or understand it. You're just getting a grasp of the general area of law that it covers, maybe some general parties, but really you're not noting anything down. You're just sort of having a quick read and sort of navigating to the general area of law that it covers. And then once you've done that, that's when you read it through subsequent times and identify issues, facts that might be important and things like that. But really you're going to read the moot problem so many times that first read through is just finding the ground it covers and not getting overwhelmed by detail.
She just say quickly, if anyone has any questions while we're explaining some of the stuff that doesn't make sense, if we jump to things, then do feel free to raise your hand or whatever on Zoom. But yeah, the same as what Isabel said, definitely just read it through a few times, not trying to get anywhere, but just to understand it, make sure you're not reading it too narrowly, because as soon as you start thinking what side you're arguing for, what the issues might be, and you're aware of some maybe areas or aspects of the law that you might be able to bring in already, you're going to start narrowly reading the problem. And what you need to do is make sure that you know the whole problem at the start and you don't miss out, even if you're doing a separate issue. And sometimes if you're doing a moot with two of you as counsel, and you'll have quite separate issues, you need to understand what your co-counsel is also speaking on. One that comes into later, whether you're going to contradict them or not, which you want to make sure you don't. But also you just need the whole picture understanding. So you'll go into detail, you'll go narrow later on, but at the start, you need to make sure that you understand the big picture of this case. What is it really about? When you're developing your theory of your case in a moot, that can't just be super narrow in your issue. You need to understand where it's coming from. So yeah, that would be sort of say my tip is just looking at that first, then annotate it, highlight it, make notes, scribble things, question mark things, all that kind of stuff. By the end of a moot, my moot problem is in tatters, literally with scribbles all over it. So you want to read it heaps of times, and yeah, then you can start delineating throughout the problem. What are you looking for? Some are facts that are useful for you, some are points you might want to look into, some things that are positive for your side, and then also noting what facts are positive for the other side, and you're going to need to argue against them.
Ira, did you have anything you wanted to add to that?
Not too much. I really agree with just really internalizing and absorbing all the facts. It's quite important, I think, to understand how you kind of digest facts, because we all kind of have our own way of doing that. Sometimes I think drawing like diagrams or timelines might help if you have quite a complicated set of facts, but yeah, ultimately it's just up to you to decide what works best for you.
Sweet, and I just wanted to pick up on something Monique mentioned, and you mentioned the theory of the case. I think that's something that's going to be cropping up a lot throughout this workshop. So Monique, did you just want to explain kind of what that is and how you're going to pick up on it when you first read the moot problem, how it's going to evolve as you develop your arguments?
Yeah, so the theory of the case is sort of the crux of what you're arguing about, or why this has come to the court at this level. What are the issues? Who are the people involved? Your theory of the case is less legal and more what is happening here. And what you want to develop is a few lines or a small bit, basically, that just you can describe the entire case, and not in a way of the legal issues or anything, because you'll do that later, but something that if someone who didn't know anything about the case asked you to describe it, you could in a few lines sum it up and what was really at the heart of it. Because it's easy to get bogged down by the law and little issues, but really at the heart of it, you need to be thinking, okay, well, who is asking for what and why? What are the situations, and what's at play here? Is it rights at play? Is it matters, that kind of thing? That'll depend on whether it's criminal issue, commercial, civil, that kind of thing. But you kind of just want to understand it in its context. And so, yeah, when you're first reading the problem, you'll start to get a feel for it. As you do research and you're writing your arguments, then you'll start to maybe phrase your theory of the case in a way that reflects your side a little bit as well. But yeah, I hope that helps explain it for now.
I think that was pretty comprehensive. If any of the other panelists wanted to add anything to that.
I would just say that when coming up with your theory of the case, it's important to, as sort of Monique mentioned, it will develop organically as you progress through your preparation. And you probably won't come up with it until you've actually finished doing the prep, because that's when you are fully on top of all the material. But it needs to be as simple and easy to understand as possible. Some areas of law, it could be easier to have a simple theory of the case because it's more based on principles. Whereas if it's a bit more statute heavy or technical, it can be a bit harder, but really it just needs to be a simple concept that you can weave again and again throughout your oral submission to bring back every time you're stuck on a question or they ask you a question and it's difficult and you're trying to bring in different areas of law. It all comes down every single time to your theory of the case. So for example, my stout moot problem was on vicarious liability. And my theory of the case was simply that people who create risk must be responsible if that risk eventuates, which is just very simple. But I mean, every time I was stuck on a question, you just bring that back in. And when it's simple, it's really easy to remember and weave in throughout the entire moot.
Iru, anything you wanted to add to that, or?
No, I think they covered it pretty well.
Yeah, no, I think that was pretty comprehensive. And we know that a lot of the students in here tonight will be doing the John Hague moot and the criminal law moot as well. And I just wanted to know if any of the panelists had any tips on approaching criminal law moot problems in particular.
I mean, I can't speak for the criminal law moot because I've never done it. I was just in that one odd year where we didn't have a moot for that. But so I'm thinking in terms of John Hague. I guess in criminal law moots, your role as an advocate kind of comes through a bit more sometimes than if you're like representing a big corporation. You might feel a bit stronger about it if your clients really suffered an injustice or committed one. But I think I guess this goes, everything I'm saying kind of goes for most moots, but it might just be more specifically relevant in criminal moots is don't pretend like all the facts are in your favor when a client has potentially done something really bad, and don't try to ever downplay what they did. There's a very fine line to walk between yeah, my client was really unreasonable here, but versus but still on the law they still deserve to win this case. For instance, in the AWLA moot that I did, I was representing this guy who basically locked these 3 women up and just forced them to do labor and didn't let them leave the house. So obviously I wasn't going to be he was a bit of a bad host, but that's fine. And I went with more of a, he wasn't actually guilty for the crime that he is currently being convicted of. Who knows, he might be guilty of something else, but it's just on the law, it's not that. So that was a bit of a tangent, but basically you might want to feel quite strongly about it, and you might be really oh, I need to get this person justice or something like that in criminal law moots, but maybe watch out a bit for that.
Yeah, I'll just add a point. I totally agree, Iru. And I think in line with that is in criminal, maybe it could be easier to sort of slip into arguing the facts, often because the facts can be quite salacious or interesting. And so remember, when you're mooting at an appellate level, you're not usually arguing the facts, or if you are, it's in a way in the legal question. So make sure you don't then start falling into the trap of arguing some of the facts, which can be quite easy to do. And then the other thing is just your language when you're talking about the case. And so in crim, it can be quite easy to get quite emotional or use quite exaggerated language when describing things. And you just sort of, as I was saying, kind of walk that line between rightly appealing to the judges and there are humans involved, and so you can have that element of emotion, well, sort of that recognizing that it's people's lives, but at the same time you still have got to ground it and center it in the law and make sure that your language isn't so inflammatory that it takes away from your argument. And this is difficult because different judges will prefer different things, but it's always safer not to be too inflammatory with your language, which can be easy to do in criminal law, I think.
No.
I completely agree with both. And one thing I would add, at least from my experience with John Haig, we had an evidence law question. And in criminal law, all moots, this is applicable, but particularly in criminal cases, particularly evidence cases, what's really important, although it's not about the facts, is the facts compared to the facts of the authorities you're relying on. So if, for example, you're talking about whether evidence should be admitted, and you're saying it shouldn't be in this case, but it was in a previous case, you need to be prepared to explain on the facts why this case is different from that one. And so I'd highly recommend really being across all the facts and the small details between your case and the authorities in any case you're relying on, or any case that's in the authorities list that the other side may rely on. You need to be prepared to explain why factually this case is different from that one that justifies a different outcome. And this is true for all moots, but particularly true for criminal law issues, when often you've got the principles and sometimes it is just about how the facts apply to those principles.
So I see we've actually just received 2 questions. The first one is, when is the first year moot actually held? So I might direct it to you guys, but I'm pretty sure it's second semester. The first
I
year moot.
believe it is, yes.
When it's held. And our second question is, what is the most discount you could apply to a defendant in crim? So it really just depends. So, and that's sentencing specific, I'm guessing. So I'm guessing maybe that this is a sentencing moot in criminal law. So in sentencing, it's really about seeing, as Val just said, even now, is, what discounts other cases have given, and then compare facts. So sentencing is definitely very much an exercise on the facts of that case, because there are so many differences between them that you can't apply sometimes the same exactly. But what it does is it gives you an indication. So you can say offending, or you can say, an aspect or a feature of the offending or of the offender. In the X case was this, and they got a discount of 10%. In this other case, the feature of the offending or the offender was Y, which was greater or something. So then they got a 20% discount. Our facts lie somewhere in the middle, so I would give 15. And that's what you sort of will be working between. It's hard to say the most discount, because you'll get discounts for different things, but you can get pretty generous.
You can. And I think I don't know about overall in terms of all discounts combined, but there definitely is case law. For example, on for time spent on bail, you can get generally between 30 and 50%. So each different discount, there may be cases saying what the most could be, but I think overall there isn't a set maximum with all factors combined. But that could be wrong.
80%. Maybe slightly on the high side. But again, it depends. We haven't seen the facts or any of the features. It really just depends in the end. But remember, and I think this goes back to all mooting as well, is it's something Natalie Walker, the Crown prosecutor for Manukau, said in a talk once. And she said, you want to be the most reasonable person in the room, because the most reasonable person is the one the judge is most inclined to listen to and agree with. And so when you're figuring out things like discount, you obviously want to do the best for your client, but you need to find that balance between, pushing it and asking for a bit more than maybe what they probably deserve, but not going too far that then it takes away from the credibility of your submissions, the credibility of you as an advocate, and just being reasonable. So have a look back through in each of the parts of the discount and see for each one, is it appropriate?
We've just got a really good question. All questions are good, but this one is really good because we didn't know this either, about the speaking order, and should the second, third and fourth speakers attempt to rebut the oral submissions of the first speaker, or do you simply focus on written submissions? So it goes senior counsel for the plaintiff, junior counsel for the plaintiff, or appellant, and then senior junior for the respondent. Technically, yes, in terms of rebuttal, but even the first speaker needs to in some way indirectly or directly address the submissions raised by the respondent. That's actually feedback I got once from some judges, is that because it's not like debating which I think you have rebuttal time. We don't have that in moots, at least to Auckland. So anything you can say to address the other side. You don't have to say, they said this, I'm saying this, but you can weave it into your argument. And when you are the respondent, you can do that more directly, but even the appellant or plaintiff can and should do that indirectly.
And I think that's a really hard, again, one to sort of balance when doing a mooting, and especially if you're appellant, is that all you'll know is from the written submissions. You'll gather maybe what the other side is going to say, and you definitely want to make sure that you're in some way responding to them within your own submissions. You might never say explicitly in response to, but you might weave in your submissions that essentially oppose or provide a counter argument to what the respondents are saying. If there's a really particularly strong point or something, then you could possibly say, respondents have raised in their written submissions at, and whatever paragraph it is, and you could sort of respond to it that way if you really wanted to highlight it. But otherwise, as long as it's coming through, respondents, it's obviously a bit easier because you then get to also listen, and you definitely want to be responding, because at the end of the day, appellants could write written submissions, and then they go up, and in their oral submissions, they could be slightly different, or the issues that were focused on with the judge were slightly different. You need to make sure that you're responding to that, not your pre-scripted sort of thing that's based on the written submissions only. You need to make sure that you're alive to what's happening in the oral submissions. Otherwise, you might miss out on actually responding to an important point that really only got drawn out in oral submissions.
I think we've got a hand raised from Henry. If you want to unmute yourself, mate, and go for it.
Sorry, I asked that question. Thank you so much for answering it. So the order is senior counsel for a plaintiff or appellant, junior counsel for the plaintiff or appellant, and then senior counsel for the defendant or respondent, and then junior counsel for the defendant or respondent. And I guess, how closely do your oral submissions have to hew to your written submissions? Because I guess what I'm worried about is we're speaking for the appellant, so I'm worried we'll be responding to what they said in their written submission, and then they come up with incredible arguments in their oral submissions that wasn't in their written at all, and we're not able to respond to that.
So that's a good question, and one time I had that problem, and normally I do a slightly odd approach where actually I write out my written oral submission before doing my written, so I can make sure I have the best submissions for my argument. And I didn't do that this time, so of course then I realized, oh, this is terrible, I should not be making these arguments. And thankfully the appellant raised the opposite to what I actually wanted to say. So when I got up to say my oral submissions, I just said, in the interest of responding to the appellant submissions, I will only be addressing my first and third submissions. And afterwards they were like, oh, that was great, you addressed it. And inside I was thinking, brilliant, because I did not want to address the second. So long story short, you can change your submissions. Your oral submission just needs to be what you best think covers what you need to say, as well as the appellant submission.
Okay.
Yeah, you obviously want them to be as closely aligned as you can, but it's understandable where sometimes as you're developing your oral submissions, you might go slightly different. But if you're making quite a different point to what was in your written submissions, that might make the judges go, hang on a minute, then it can sometimes be worth front-footing it. But that all just sort of depends on whether you think it's clear enough or not. And that's why, to be honest, written submissions are often kind of your skeleton argument, because it gives you the foundation, which shouldn't really be changing. And then how you develop it might change, and that gives you room and flexibility.
Okay.
Yeah.
Awesome. Thank you so much.
No worries.
We have a few questions
yeah.
about sentencing discounts. Perhaps just a disclaimer, we are not sentencing experts.
Yeah.
So I think perhaps maybe we'll address the mooting ones, and then if time we can come back to those, because I think the mooting stuff is more applicable to everyone here, and then we can address those later if there's time.
Yeah, maybe if people have more specific questions, we could answer them at the end. And yeah,
But the
One of
mooting
the-
ones.
one of the general ones is, do you have to present the facts of the case when you're the senior appellant? So yes, often the first speaker, senior counsel for the appellant, what people tend to do is just ask the bench if they want to summary of the facts, and so that way you don't have to waste time saying it if the bench doesn't, but sometimes they do, and sometimes judges who are called on to judge moots really haven't read through the problem that much and are under the pumps at work. So then they come in and they actually appreciate a summary of the facts. And other times they're just like, no, get straight into your best arguments. So it can be worth asking.
There was one question above, did we address the weaknesses point?
Oh
No.
yeah.
I feel like I can't, sorry.
Sorry.
It's just like I can barely like see any questions, so I'm just relying on you for
Sorry,
them.
Oh,
yeah.
sorry.
If you want to
I
chip in,
can't see the
fine.
questions at all.
We're
So
getting
Oh,
some direct and some
messages.
to everyone. We're getting a lot
Yeah.
of direct. Sorry.
Oh,
But the
okay.
question was basically that if you
Oh, yeah.
have written submissions, should you preemptively raise any weaknesses in your case, or should you simply be aware of these and then prepare responses if the opposing side or the judges raise these weaknesses?
Oh, so sorry, I was reading
all
other
good.
questions. So yeah, I think in your written submissions, often you don't have too many pages to fit in stuff. So definitely just put your best foot forward, I think, in the written submissions, and you'll acknowledge the weaknesses or anything in your oral submissions. But if you have a counter to that weakness, you can put that in your written submission. So address it if you can counter it. If you can't really counter it, then it will just come up in oral submissions and you'll say, yes, I appreciate that, but it still doesn't make a difference because of X, Y, Z. But yeah, anything, Iru, you want to add?
Yeah, I think it's just about, for a lot of these, like figuring out what is like a very glaring thing that you absolutely have to address versus what is more just something that might be raised and might not. And just on the earlier point about like responding to your like other counsel, I think I just had one thing to add, and that is just like kind of take them at their best when you're responding to them. Like don't fixate on like tiny little things, because that just sounds petty and like you're just trying to mess with them, and that's not what you're trying to do. So that's just a note to keep in mind. I also just got a question about if I can describe my mooting style. I've never really thought that much about it because I think there's no like set types of mooting style. I kind of just do what I can, just try my best. But I guess for me, I just try to seem like what Natalie Walker says, like present myself as being like the most reasonable person in the room, and come off as like trustworthy and like you should be listening to me. I'm not sure if you have any thoughts on what your mooting styles are.
I would say my mooting style is probably quite serious, but that also is perhaps a reflection of how I come across when people first meet me. And I've had to work on making it a bit more slow and composed. But the best tip, and similar to what you said, Iru, is I got from a judge, or it was general feedback to the group of us, was when you're mooting, you have to be your authentic self. Don't try mimic someone else's style. You have your own unique way of speaking, way of conversing with the judges. And if you're ultimately trying to come across in what you think is mooting style, it's going to come across as a bit fake. So you just need to do the prep and then confidently and clearly present your submissions. And as long as you do so in a way that's authentic to you, and you just make sure you're speaking in a clear manner, that'll be a great mooting style.
Yeah, I definitely echo those thoughts as well. We've seen so many different mooters over the years win moots, and they've had completely different styles. I've seen someone win a moot who was very conversational, very relaxed with the judge, even making a joke here and there. And then there are other mooters who are extremely formal, not one word out of sort of rhythm or that kind of thing. So it's, again, your most authentic style, and that way you'll also be able to answer questions better. It won't be like you're saying a script in one way and then get detracted from it if you're answering questions. But yeah, and also just, you can have fun with it. I mean, I've definitely over the years tried sort of different styles. Of some moots I've done more relaxed, some more formal, some, you watch counsel that you like in court or something like that, or hear a lawyer speak and you try and copy them in the mirror while you're practicing your moot, feel free to do all that kind of stuff. But as long as it's something that is coming from you and there's not one way to actually present a moot. But yeah, so, okay, we have a lot of questions. I'm thinking, should we hold those for the end maybe and keep going so we get across sort of generally all the topics we need to cover tonight, and then maybe we'll answer questions at the end?
Yeah.
What do you guys think?
We can also try address some of these. We'll keep them
Yeah,
here. And then as we go through the topics, we will try weave them in.
Yeah. And if they weren't answered at the end, let us know.
I think that's probably a good idea because the structure has sort of gone to pot.
Yeah,
But-
sorry. And we'll be here all night.
I think back to this questions about sentencing, you guys spoke a lot about, looking through the authorities carefully and seeing how they differ between your case and the facts in front of you. So maybe a point on researching, because I know John Hagan, the sentencing moots are all independent research moots. The best way to sort of familiarize yourself and gain a thorough understanding of law that is going to guarantee to be new to you.
I would say the first port of call for any research question of any kind, whether it is a moot or law, like school generally, is the commentary. They
So
provide
helpful.
a clear, concise description of the law, examples, and once you understand that from the commentary, that's when you can go out and look for specific cases, but always start with the commentary. Well, that's my advice anyway.
Yeah, I am, as someone who only discovered how useful commentary was in my 5th year of uni, I cannot recommend it enough. Just textbooks on the area. I mean, you might find, and I think this has been with pretty much all of the moots we've done, it's been on a topic, an area of law that we have never learnt. So, my stout was competition law. And so I went straight to the textbook and just read up on the relevant areas that I knew. So I obviously didn't read the entire textbook or just read generally stuff that wasn't relevant. I still looked at, okay, what are the sections applicable in my moot? What is the areas of competition law that it's going to? Then I went and read the commentary just on that part. And I see 2 questions. So yeah, most of the moots, I think all of
Okay.
are closed authority moots, which is great. So those are really what when it's closed authority, those cases are the only ones you're citing in your moot. And really those are the heart of it. So I often tended to read them first, to be honest, just because I knew that those were the ones that I was going to be citing. But I often didn't understand some parts of them. And that's when reading commentary can help, which you obviously can't cite. So questions like, is it worth reading outside of closed authority list, reading at commentaries? Yes, because it helps your understanding of the law, the context, that kind of thing. And that will help you develop your arguments and understand, sometimes they explain what a court was saying in a decision in your authority. And you're like, oh, that's nice. When I read that case, I did not get that from that. So it can be helpful like that, but you obviously can't cite it. It's just something to help your understanding when you're reading the cases. But it definitely can be worth it, especially if you've never seen the area of law before.
Yeah, no, I just echo all of that. And I love closed authority moots because I feel like it just helps you narrow your focus down so much more. And yeah, just becoming familiar with these cases. And yeah, I tend to go to the cases first if it's closed authority, and then look at commentaries either like on those cases or on just the area of law in general. But yeah, I think hopefully that answers all the questions there.
And sorry, one final point I would say on just research or authorities is know them. You have to read the cases. There's no shortcut. Reading the commentary is not enough without reading the case, because it's, as Isabel was saying before, it's the deeper understanding and the little facts and details and cases that can make or break your argument. And if you miss that because you haven't pored over the case in fine detail, a judge will probably bring it up and then you'll be stuck. So it's just definitely something that you can't really avoid a mooting. It takes prep, but try and see it in a different way. I mean, I always found it hard to read cases for uni, but when it came to a moot, I had no problem because it was fun. You're reading a case to look for stuff that was going to support your argument, and you're got that in the back of your mind. So try and, if you're struggling to read cases, try and look at them in a different way as to how you would at uni.
With those authorities, like you said, those like really small details and the facts, and then people should be pulling out what other materials should you be pulling out and looking for in those authorities?
I would say the key, as well as the facts, you need to know the reasoning. So, for example, not just these are the facts, this is the outcome. Well, why was that the outcome? Because that's also going to be really relevant to your arguments and also any questions you answer. So, yeah, reasoning and principles.
Yeah, and also just knowing the basics of the case, because if you bring it up, you then have to expect that you can answer anything on it if the judge asks. So you need to be able to just describe what the facts are. You need to be able to say what court, when it was there a majority or minority decisions? What did the majority say? What did the minority say? Why? If you're asking, especially if you're citing a paragraph. So if you find a paragraph that's useful, make sure you look that especially if it's a split decision, if it's under majority or minority, because you're going to reason why the bench that you're arguing in front of, why they should maybe take the minorities approach or the majorities approach. So you really need to understand that. Otherwise they'll say, the judge will ask you, well, why should we take that when that was the minority decision in that case? And you need to have thought through your answer first.
And I guess this might be quite obvious, but like knowing how the case differs from your set of questions. I think I found judges actually like to ask hypotheticals a lot. Like, how would this case have turned out differently if this one small fact was changed for either like the authority cases or for your argument? So just having a really good think about the authorities, like in terms of your problem question.
Mm-hmm. And we have one more question that's related to authorities. Is it so, and often in moots, this will be the case where the problem splits into two different areas of law. Is it as important to read the authorities for your partner's case? So if you can be confident that your partner's authorities have no relevance whatsoever to yours, then you probably don't need to read them. I don't think we would read each other's, but we would definitely explain to each other, or if we were reading through one of our cases, we would say to each other, if we found something that might be relevant, and would say, oh, by the way, just like maybe would you want to have a look at that in this case, just in case? But otherwise you could probably stick to your own. But if there's a lot of overlap, then it might be worth, And sorry, we have another question. What does closed authority moot mean? So closed authority is when the moot problem is sent to you, it's also sent with a list of cases or authorities, and those are the only cases that you can refer to in making your arguments or submissions in the moot. Anyone?
Do you guys see any other questions that are sort of relevant to that?
No, that's all for authorities, I think.
Okay. Sweet. We might fly through then and briefly touch on written submissions. I think we've already talked about them before, but I know that the written subs are often limited in these sorts of moots to 2 or 3 pages. So just briefly, what needs to be covered? It's in like essential stuff, and how do they kind of differ from your oral submissions?
Irie, do you want to go so we don't get your thoughts?
Sure. I guess so I'll first just emphasize that don't be too stressed over your written subs. If you have to prioritize, always prioritize your oral subs. So don't fixate on like every little word. If that's time you could be using to polish up your oral submissions or think of questions, that kind of thing. And I always think of written submissions as just being like the outline or roadmap or like the guide that you give to judges to help them navigate through your oral submission. It should definitely have all the main points of your written submissions and I keep getting them mixed up now, of your oral submissions and what you are using to support those points, but really don't, especially since you are limited in page number, don't feel like you have to spell out like every single aspect of your argument. I think as long as it's like something that someone who's never seen your argument before can follow through and like the structure is clear, then I think that's all there really is to the written submissions.
But yeah, I completely agree. And yeah, don't stress too much about them, because in most Auckland uni moots, they don't really play much of a part at all in terms of the assessment of your moot. One thing I will add is that sometimes in the senior moots, in the junior moots, especially first year moot, which is so often privacy, you've got your elements. So your submissions just revolve around the elements. You have, each person will have one separate issue from or maybe two sometimes, and then you have one submission for each element. In the senior moots, however, you might have an issue without clear elements. And so when you're writing your written submissions, the first step would be to think, well, what actually are my submissions going to be? Am I going to have 2, 3, or 4? And one of my biggest tips for that is don't write your written submissions until you have a really good grasp of the problem and the authorities and the kind of separate arguments you want to raise. So, for example, one thing I do when reading the authorities is to have a Word doc, and I would just sort of copy chunks of the different authorities into different sections. So say it was on, I'm going to go back to vicarious liability because that one is the most recent moot I did. So, you might have general statements about the principles of the tort itself. So you put that in a chunk, and then those chunks of sort of general topics you gather from the authorities and the problem itself then form the basis of your submissions. And that way it can be easier to sort of decide on what your submissions will be, because otherwise it's very difficult in the abstract to break your argument down into separate discrete submissions that you're going to argue in your oral submission, if that makes sense. That was quite a verbose answer. But
no, yeah, that's definitely a really good point. When you get to moots that aren't as clear cut in terms of the issues, a real part of the skill in mooting is developing those submissions. How are you going to logically separate out your arguments? What arguments do you need to make? And so that's an aspect of it that then becomes a skill in a way that is assessed or in terms of your understanding of the problem. And for written submissions, I mean, I definitely always relied more on my oral submissions to get me through moots, something that I'm trying to avoid now that I've seen the importance of written advocacy at work. But I really think, yeah, as Iru said, it's a roadmap, it's a skeleton. You want it to be just clear, simple, easy for the judge to follow, not too detailed or bogged down in detail that you will develop in your oral submissions, but rather just a clear outline referring to any authorities you're going to refer to. So then the judge can know that you're going to cite these few cases and they might want to read up on them before. And yeah, I think just being as clear and simple. I mean, it's really easy in law for us to get really technical and legalese and writing really complex way, but the best thing you can do is actually write it in its simplest form, especially in those written submissions. And it's sort of to not quite on this question, but I'll just answer it in terms of splitting up arguments between partners. Often in a moot, they will separate and say a senior counsel will address this issue and junior counsel will address this issue in the problem. So it should always be clear what you're addressing. But yeah, for written submissions, it's, as the others have said, in Auckland moots, it doesn't tend to have too much weight, but also there is pride in the work that you're giving to judges before they've even met you, and they might read it before you give your oral submission. So first impressions can count. And in terms of just spelling errors, that kind of thing, you're footnoting.
I will just say on that, for Monique and I, our first year moot, our written submissions are probably the worst piece of work we've ever produced, because we thought that the object was to give an outline but not tell the other side what you're going to say, because that would be giving away what you're going to do. That's the wrong approach. Don't do that. So if you do see those on the online database, do not copy those. That is a terrible idea, but it does show you, even if your written submissions aren't great, you can still do okay.
Yeah, it's definitely, you don't need to be hiding your good points from your written subs. Like, put them out there.
Yeah.
And often your good points are going to be ones that everyone's kind of, your other side's probably been like, oh yeah, that's going to be a good point for them. Judge will already know. So definitely put it out there and then just develop it. You're not trying to hide anything.
Just another thing I just thought of, which I don't know if it might be controversial or not, but I quite like having like the argument before the authority in a paragraph, if that makes sense. Just so the paragraph doesn't start with the Crimes Act says blah, 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 without them knowing how it's even relevant to your case. Sometimes I think that helps, but I'm sure that's just a thing that I find helpful. I don't know how far this goes.
We have a few questions on oral subs, which we'll get to, but then I think the last one we have on written subs is how much reference or detail to the facts. I think everyone can read it, the last one. Would you recommend we have in written submissions? So again, that's sort of a thing. Sometimes you'll have heaps of law to try and fit in, and other times you might only have 1 or 2 cases, and then you can maybe go into more detail, and you might be able to flesh it out a little bit more, your argument, because you're not so pressed for word count or page limits. But at the end of the day, it's still making sure that each word you have on it is necessary and useful towards your argument.
Yeah, and when you do have problems that you haven't got substantive law to rely on, it is going to be more factual principle based. That's fine. It's just about knowing your problem and making that judgment call about what you include. I think there are lots of good examples on the Mooting Society database, with the exception of our first moot submissions. Everything else is really great. So have a look at those, and maybe even have a look at the problem, so you can see what problems were kind of similar to yours in terms of area of law, and then look at those submissions just as a guide on whether you're achieving the right balance.
Yeah, I mean, in my sentencing moot final, I got told that if it was on written submissions, I would have lost. Thankfully, it was on oral submissions, so I don't know if I'm the one to be giving advice on them.
I think on oral submissions, I think that's probably the topic most people are most interested in. We'll start with a question we have in the chat about the questions judges will ask. So how many questions can we expect judges to ask us in a 15-minute speaking period? I think this is for John Haig. And how much time should we dedicate to answering those questions?
It so depends on the judge.
Yeah, and it also depends on how long you should spend answering that question. That's the most unhelpful thing, but it's the truth.
I think the tip is, and I think it's hard, I've differed in different moots, but sometimes I've had, in my oral submissions enough to fill up the entire time, but I know that half the questions I get I will use what's in my oral subs to answer them. So I won't repeat them when I then get to that point in my oral subs. I know that I've already answered it. And then and 2, that there are just some points that I know that aren't as important for me to get out. So I probably won't say them as I'm running out of time. But the other times I've also, I've tended to usually go less. So if it was a 15-minute moot, I might have oral submissions maybe around 10 to 12, and I still won't get through them all. But I personally prefer to have more there, just in case the scary times you get a really quiet bench and you're sort of looking at them, waiting for them to ask a question. But you should have enough questions. I think this is the one, and this is the most fun thing I think we find in mooting, and what's probably also the scariest thing for a lot of people is that it's just so uncertain. You don't know if you're going to get peppered with questions at the start or at the end, or they're going to be balanced throughout. So I think you've just got to know what you need to say. So you might have oral submissions that could take 12 minutes or 15 minutes reading them out, but you need to have highlighted what are the crucial aspects that you have to say before you finish that moot, because otherwise you'll have failed to make a point. Otherwise, there's a lot of other filler things or development that you might say that kind of just emphasize your point more, but make sure you just have a foundation of what are the things you have to say, and then you work questions in around that.
And as for like speaking time, I would say give it, like your answers should ideally be quite succinct, but also give it as much time as it needs. Make sure you've really addressed the judge's concerns and answered the question. Don't ever feel like you are really rushed to return back to your submissions or like get away from this situation. Yeah, just really take your time in that sense.
And embrace it. I mean, it's a really cool part of mooting. So in my nationals final, Justice Glazebrook questioned me for 18 minutes of my 20 minutes of speaking time. So I don't think I even turned my second page of my oral submissions at the end. So it really just depends, but also that was really fun. And in all her questions, a lot of my answers was stuff drawn out from what I had prepared in my oral submissions, but I just had tailored it in a way that was answering her question directly. We've got a couple of questions going to the same point, which is a really good point and something that we sort of learned through our years of mooting. And it's, you've written your written submissions. How do you make your oral submissions different? You don't just want to sound like you're reading them out or saying the exact same thing and repeating yourself. And that's a point that someone said, I can't remember, one of the judges in one moot said, you want to speak to your submissions, not say them. Oh, sorry, your written submissions. So they've read your written submissions. There's no point necessarily reading them out or saying it in the same way. What you want to do is, I'm still figuring out what it means to speak to your written submissions, but at the end of the day, it's, pull out the really important points that you actually need to discuss and talk about and raise issues and that kind of thing, as opposed to just reading out what you've already said. Put it in the context, put it in a different way that comes across better and maybe links things in or that kind of thing. What are your guys' thoughts on speaking to submissions?
I agree. And as Aru said about the written submissions, they're a framework or a skeleton. They shouldn't be your whole argument. So as long as you have got your written submissions as a skeleton, by including the context and elaborating, it's fine if your oral submissions are just elaborating on your written submissions. That's fine. That means your written submissions are very good. They're matching what you're saying. So don't worry about that. But just make sure written submissions are a framework. You don't need to squish everything into those.
Yeah, definitely. Like, you shouldn't be in a position where you feel like you're just reading out your written submissions, because that probably means you wrote a little bit too much there. And also the way that you write and the way that you speak are quite different. So just keep in mind of that. And I don't even know if this is answering the same question anymore, but I've just gonna add it because I remember it now. Like when you're preparing for your oral submissions, don't be like unnecessarily verbose or like say stuff too formally, because that just sounds very unnatural. And if you feel like a word is really clunky and you're having trouble fitting a sentence together or that stuff, just make sure to simplify it in a way that actually sounds natural when you're saying it out loud.
Definitely. And this is something that goes a bit back to written submissions, but ties into why when we say that you shouldn't have, your entire argument in your written submissions, don't change the margins or the font size or the any formatting you can on a Word doc to fit, entire paragraphs in. Because I can tell you when you're on the other side as a judge and you see it, it's the last thing you want to read. And that's just the honest truth. So as hard as it can be sometimes when you're so restricted, I think for nationals, we only had one page essentially for our written submission. So one page, your 20-minute oral submissions have to fit on. So it really then does become your skeleton argument. And so don't change your margins and everything like that and put in massive paragraphs, because one, you're taking away stuff that you can develop on in your oral subs, but two, it's just a really difficult first impression when you see that, and it's very glaringly obvious when you're staring at it on paper. That would be one tip, is not to do it. I know it's very tempting to do it, but try not to, and really make it a skeleton, so then you can actually develop your point in the oral submissions. So I think we'll get to maybe questions on questions in a bit, but the exemplar submissions that we're referencing, there's a Google Drive, I think, on the Mooting website, if it's the same as when we created it, which has got examples and folders of different moots. And again, it's worth looking across different moots and at different submissions. So so many written submissions will be written differently, and they can all be good in their own way. So have a look, see what ones you might want to take from, what ones you, or you can take bits from written submissions and see what kind of works best for you.
So I think the website is like it's supposed to be like relaunched today, or tomorrow or something like that. So just if you don't find it immediately, it is there, and we will make sure that you are able to see them.
Thanks.
There are also there were videos of old moots up there as well. So you should watch those apart from don't watch
Our
but other ones.
Yeah, it's that's actually one thing. And I think this is what Isabel and I credit our success in our first year moot to, was that we went up and watched the Stout Shield final in our first year. And we were watching some of the greats of Auckland Uni mooting, and we had literally no idea what was going on. And it was quite intimidating, but it was the most eye-opening experience to actually see what a moot looked like before we did it ourselves. Because otherwise I had to Google what a moot was. I had no idea. And so if you can watch, some of the videos, the moots online, you'll get an idea of what it's like for council to get interrupted, when speaking, how they get interrupted and answering questions, how they pause, how they answer it, do they answer it directly, tie it back into something else, how do they then move on, even just phrases that you can pick up, like, oh, and Your Honor, that to answer that question takes me to this part of my submission, which I'll go to now, things like that you pick up from watching other people speak. And I remember, we had seen in the one we watched as first years, there was a really difficult question, and the Muta had answered it the best she could, and then she said, Your Honor, I cannot take it any further or something. And immediately we were like, oh, that's something we can use if we can't take a question any further. So it's definitely worth watching moots if you can, to pick up things like that.
In terms of kind of answering those questions and like sort of engaging the bench, you've mentioned some quite interventionist benches. How do you gauge, I guess, the temperature of a bench, and how do you adjust your style in accordance with that?
I guess kind of what Monique has talked about, which is distinguishing between what you absolutely have to get out versus what is more there to say if you have the time to say it, as well as the point about how, like, sometimes the questions they ask will be stuff you're about to say anyway. In terms of, I'm not sure if I'm interpreting like temperature right, but if a judge likes, I often find that judges are more interested in like one part over another. And so that could be something good to look out on. I don't know if this is a common thing, but sometimes I even just go like, when I've said everything I needed to say on one submission already, and there's nothing else, like something like, Your Honor, I can sense, this is not great wording, but like I sense that you are interested in this part of my submission, so I will go into this further now, just to kind of signal that I am responding to them and to the room. And also watch out for if you answer the question but they still don't really look that convinced. Sometimes it can be nice to ask if you have any further concerns, or just like those little things in terms of reading the room.
Completely agree. And adding to that, I think one of the great things about having largely left COVID behind is that most moots are now in person. And what I did and found really valuable is watching the facial expressions of the judges, particularly when you're the second, third, or fourth speaker. You can watch how they respond to answers by previous speakers, and particularly if you're a respondent, you can see what questions they're really digging at the appellants on, and you can try, if you think they're not particularly convinced by the appellant's answer, you can then bring that into yours. But you can very quickly get a sense of the kind of answers the judges like and what kind of questions they ask by very closely analyzing the interactions of previous speakers with the judges. So that's a huge advantage of not going first, but equally if you're first, You can quickly get a sense of the judge's response to your questions by, again, reading their facial expressions, watching whether they nod or whether they're frowning, those kind of things are actually valuable observations, and particularly important if you're not 100% convinced on what you're saying. It's very important to read whether judges accept what you're saying or not, because if they're not accepting it straight away, it's better just to drop it actually than to keep pushing it and they're not going to accept it.
Yeah, 100%. I mean, reading the bench, I cannot recommend enough. It's so useful. You'll be able to tell. Also, a quick tip is whenever, if you're trying not to look at your submissions too much and you're trying to have more eye contact, every time the judge looks down, you look down. When they look up, you look up. That's what I've done a lot of the time. But yeah, reading the bench, like Isabel said, their facial expressions, you can hear in their voice when they're not convinced. You can hear in how they ask the question. Sometimes they just ask the question. Sometimes they preface it with, I think, I just don't buy your argument at all. I've had, I think John Haig, I think pretty much every moot, to be fair, I've argued the losing facts argument. And, I've had judges say to me, well, I just don't believe you that this could happen. And I'm like, well, and that's when you've really got to think of a different way of saying it, because you also don't want to just bombard them with the same thing over and over. And that's where you've got your essential foundation point, and then you've got your development of it with different ways, different iterations, different ways to say it that highlight different aspects. And that's what you pull in when they're not buying your argument. I, in the Nationals final last year when Justice Glazebrook was questioning me, that was all in my first submission. And again, I was on the most horrendous losing facts ever. And my second submission was an even more ridiculous argument that I had to make. And so even though I only had 2 minutes left and I hadn't gotten to my second submission, I knew that she didn't want to hear it. And I said, Your Honor, I'm guessing you don't want to hear from my second submission. She just went, no. And I was like, cool, glad we're on the same page. So it's no, not in those words. Sorry, not in those words. But I just, you could tell, I thought, well, she's totally not bought my ridiculous argument in this first submission. So there's no point even raising my second one any earlier. So yeah, definitely reading the bench is a big thing. And we had a question on questions.
There was one quick question just before when I said fourth speaker. Sorry, I meant overall. So there is only 2 speakers per team. Just clarifying. Yeah.
So this is something as well as identifying that's really useful, is identifying the different types of questions that the judge is asking you. So I've heard it in different ways, but I like to think of it in a few different kind of concepts. Like one is your just general, I don't understand question. So the judge isn't understanding what you're saying, and that's confusion, that kind of thing. That's a really good opportunity for you to demonstrate your mastery of the material, the problem and everything, and alleviate their concern so that they don't understand it. You're then, okay, you often might know some of the areas or the authorities better than them if it's an area they don't work in. So that's your chance to actually say, this is what it is. Let me guide you as to how you'll get to the position I'm arguing. And that's great. If you can identify that and really make the most of it in a moot, you are literally guiding the judge to your reasoning and your position. Then you've got the concern questions. I'm concerned that you're asking me to do this because of XYZ reasons, maybe because of policy reasons, or I'm concerned because we're going away from what's been done for 20 years, or I'm concerned that this result will lead to these other things. So identifying when they've got a concern, your answer then needs to alleviate that concern. Your Honor, it's not a problem, or Your Honor, well, not quite like that, but Your Honor, it's there is not this risk, or because of XYZ, this concern is alleviated. Then you've got lifeboat questions. So if you're struggling in your moot and if you're needing a bit of help, the judge might ask some questions to kind of get you going, or some questions to settle you. They might just ask, what are the facts of this case, counsel? Or some questions that also guide you. So if you're struggling in a moot and the judge thinks that you might be missing the point or going a bit off what your argument should be, the judge might ask you a question to encourage you to give them the answer they want. And also recognizing that is really important, because not all questions are going to be challenging you or against you. Sometimes the judge is asking a question to elicit something from you that they want to get. And if you can identify that when they ask that question, you're thinking, oh, they want me to say this, and you say that as opposed to saying, no, Your Honor, because you don't always need to say no. That's also really important, because I have seen, some mooters will take every question as a challenge to their argument without realizing that, you know, my question to them is actually to get them to a point that I want to, and that they should accept and go with it. So I think, yeah, that's another part of the skill of mooting, is like being able to identify those questions on the spot and figuring out how your answer is going to address what's behind that question.
Yeah, completely agree.
Anything you want to add, Iru, or?
No, I just really echo what Monique said. I think like once, I'm not sure if you should be doing this, but like once the judge asked me something that was entirely just in my favor, so, and I was just like, yes, Your Honor, and then I just kept going.
Yeah.
Yes,
Prime
I think it's
example of
just
like understanding the question, you know.
And don't like just saying yes, Your Honor, when it helps you is enough. You don't have to elaborate.
yeah.
Sometimes they just want to check. They're like, so counsel, are you saying this? And you just go, yes.
Yeah.
And you're like, cool, move on.
But sometimes it might be like, are you saying this? And then you have to be like, yes, because if you know,
because you can hear the intonation in Isabel's voice. Then it was like, are you saying this? Like, really? And when you hear that in their voice, you're like, okay, I need to explain why.
And also on that, I mean, particularly in some of the senior moots, sometimes the judges can be deliberately provocative. So, for example, one question I had from one judge was, so it's a money grab. And my answer was, no, Your Honor. It's about making sure those who create the risk are responsible for it. So you can say no. You can, if they're being provocative, without being rude, of course, you can respond back with authority. And as long as you're answering questions, actually on that point, a really great way to answer questions is, if possible, with a yes or a no, followed by an explanation on the facts backed up by authority. So the 3 steps. You don't always need the facts or the authority, but that generally is a great way to make sure you're covering the bases. And as long as you answer with a clear, confident tone and backed by reasoning, it should be a good answer.
Yeah, and so we've got a question: how do you pick up on when the judge wants a specific answer? So again, that's just sort of, it'll come with practice, for sure. I mean, remember, this is Isabel and I are speaking from experience of having mooted, I think, every year for 5 years. Yeah. And so, it really is coming with practice, different kinds of judges and different moots. But I think it's just trying to identify, like I was saying before, why are they asking that question? So when they ask it, think, is this because they're concerned about overriding a right? Or is this because they aren't understanding my argument? Or are they actually saying something that's positive for me and they want to check? So just trying to pick up on that. And that's why you need and should take time in answering a question. So when they ask it, even though it might seem like a lifetime, take 3-5 seconds to think about your answer. You know, think about it, look at something if you need to, and then give your clear answer. And like Isabel said, if you can say yes or no, say yes or no. There's nothing more obvious than that. And the better you know your material and the better you know your submissions, the easier it will be to give a clear answer, because you'll know what you can say and what you can't.
I can't emphasize enough the importance of pausing until you know what you want to say. There's nothing worse than trying to answer straight away and halfway through your answer realize this is actually wrong. I should have said something else. And then you've dug a hole too deep and you have to dig your way out of it.
Or you don't know where it's going and you're halfway through and you're like, oh, I don't know what my point's going to be.
So just pause, think about your answer, have a drink if you need a quick drink. And then resume.
Depends on the judge. And one other question that's probably, I say, probably the most difficult one is the hypotheticals. And that is where it can often highlight how well you know your case and the authorities, because you're thinking on the spot, how would what you're saying or arguing would apply to a different fact scenario. And that can be really difficult. They are challenging. And, you know, when I remember getting one in my stout final, and I was one day out of having COVID, and so I had not done the prep that I necessarily would have liked to. And I remember getting a hypothetical question and sitting there and thinking, I don't know my case comfortably enough to be able to answer that and know that I won't be contradicting my overall argument. So that was a really good example of how well knowing your stuff counts. And also sometimes questions from the bench could be tangential questions or distracting, or might take you onto something that's not relevant. And if you know your case well, you can appropriately say to the judge, Your Honor, your question is referring or is asking this issue in respect of this, that, respectfully is not at issue here today, or is not relevant to what my argument is because XYZ. And so sometimes I'll ask questions like that to see whether you get caught and follow their question that doesn't relate to your argument. So if you can identify that and draw Your Honor back to the your oral submissions, that's really good.
Did you guys have any other questions in your chat about oral submissions that came through?
We've got one. It's actually probably general, but it applies to oral submissions. And that is, what if your client asks for something that you don't agree with? Do you still argue for the sake of getting something? I think the key for that would be on all moots, unlike in real life, thankfully, you're not arguing you're not going to win based on the facts. You're not going to lose based on the facts. So even if you don't think you've got a winning argument, even if you don't think that the facts, would have any chance of this, you're just doing it for the purposes of the moot. So even if in real life you might have an ethical obligation to be like, look, this is a hopeless case, in a moot that doesn't apply. So don't get too worried about that for mooting purposes.
Yeah. Oh, sorry. Were you finishing? Oh no, it's just adding to that. Like sometimes it's almost a good thing if you are on the harder side, because like the judges recognize that and they'll be quite impressed by what you are able to make out of it. And I sometimes think of it in terms of like what the things that you can control about the case versus what you can't. And it's just like you have these resources there and you're just trying to craft it to make it into the best argument you have with the set of facts, with the side that you do have. And if you do that, then yeah, that's really going to impress a judge.
Yeah, and I think remember, and this is in real life as well as lawyers, you're the advocate for your client. It's not necessarily what you agree with. You are just the advocate in this legal environment for the client. And obviously there will be other things in real life about what arguments you can and can't make. But at the end of the day, it's not what you believe, what you think, but you're just the advocate for the client and what they're asking for. If you can, you need to do your best. You've got a duty to argue it in the best way for your client. We've got a question. This is a really good one. Do you memorize any of your argument off by heart, read off cue cards, or try to speak more in the moment? So this is another one that's really dependent person to person. And I know I've definitely changed. I personally have in the past always written out an entire oral submission and sentences, but that is because I know I'm someone who doesn't necessarily read off. So even if I have a script in front of me, I'm very comfortable speaking to it and not necessarily reading it. I won't get always, drawn down to read it. But if you know that if you've got written words in front of you that you're just going to read and never lift your head, then maybe it's worth putting bullet points. So I know a lot of people have like topic sentence, bullet points, the authorities, key points, but you haven't written it out in full. And there are different reasons for why you might want to do it in different ways. I often preferred my oral submissions completely written out because I knew that I was actually only really going to look at them when I was stuck or maybe a bit flustered. And when I'm flustered, all I want to do is read a perfectly written sentence that will get me back on my feet. Instead of looking down and thinking, oh my gosh, what do I make of these bullet points? But at other times as well, I've done less. You really just sort of figure it out. And, I've done different colors. So I've done paragraphs that I must say are in one color and paragraphs that are extra in different colors. And I think at the end of the day, it's just knowing it so well that you could know where it is that you might think, okay, I want to say that paragraph or that bit. And I really break mine down into little points. But yeah.
Yeah, I agree with that. It's a very personal approach that you will learn over time. I always write out my my oral submission in full, because I am paranoid that if I don't, I'll forget it. Although that's not the case if you're prepared enough. I think it's really important, if you've got bits of authority you're going to quote, have those, because if the worst thing you could do would be like at paragraph X of this judgment, they'll be like, that's not what it says. So make sure you've got those written out. But otherwise you can do bullet points. you should really practice. This is a piece of feedback we got from Lady Deborah Chambers Casey in our first year moot. Practice in front of a mirror. I'll do that 4, 5, 6 times. And by the time you've done that, you'll know your argument so well, you don't even need to look at your paper, and you only have that there in case you get stuck or flustered in the moment. And that's a great step to becoming confident in your oral submission, is just knowing it so well. And you can do that by looking in the mirror, and then you can gauge your eye contact. You can gauge a lot more from looking in the mirror than you can just reading it in your head or at your desk.
It might sound silly, but yeah, genuinely I've done the same. Like no shame, read it out in front of the mirror, try it in different styles, try it in different intonations, especially my opening, how I want it to sound. And yeah, by the end of it, you should be able to, in your head, jump to a certain part of it and know what you're going to say at a different point.
I'm also someone who writes my submissions out in full. But I've tried to, for instance, like highlight or bold like the main like keywords, so that like, you just look down, you glance down, and you just see that, and then you're able to just rattle off based on that. That might be quite useful as you're practicing as well, just to have. I just lost my train of thought there. Oh yeah, I've also found useful personally to have like headings, especially if judges are like pulling you to different parts, you know where your speech, well, your little rant on this one topic is, and you can always find it really easily. And it's about kind of finding these shortcuts to kind of take you where you need to be. But yeah, once again, it is quite personal, and you might want to try different things out.
One thing I would also recommend is you may, when you're doing your preparation, come across some things you think, oh, this could be relevant to a question a judge might ask. And so you should prepare a separate questions document with broad topics. So for example, it seems that your John Hague is about sentencing, and perhaps, there could...
No, that's sentencing.
Sentencing moot. Okay, well, let's say sentencing moot in criminal law, the defendant is aged 23. Is that young enough for a youth discount? Or let's say they're 22. So you could have a questions title, youth, and then you can put a few snippets from different cases in there. So when you look to your questions document, if you get a question about that, even though you didn't plan on addressing that in your main submission, if that comes up as a topic of discussion, you've got things there, you're confident to respond to that question.
Yeah, it's definitely you've got to start thinking about the questions. And this should come naturally when you're preparing your moot. If you don't go too narrow, is as you're writing something out, you'll know straight away, oh, I'm so going to get questioned on this, and you'll just know straight away. And so that's when I often tended to put stuff below in my oral submissions, points that I thought would be answers to questions on that relevant point. Or like Isabel says, you have it on a separate doc, and you just have bits of authority or extra bits of citations from cases, or any other kind of explanations that you can just have on the side, and you can have it handy so that if you're answering a question and you need it, you can look at it, and it's just a point there for you to use. And we have a question in terms of a break in speech being damaging for your case. So stuttering or saying, look, at the end of the day, obviously, if you can speak as clearly as you can, then that's what you want to, you want to speak as clearly as you can. If you have a stutter, that won't impact you in terms of how you do in the moot. I mean, by no means, and you can still come across clearly. And if the judge can still hear your answers and your submissions, then that's absolutely fine. And I think it's just really, I have a tendency as well, I think, to sometimes fill space with sound. So I then try and just shut my mouth. It's a point, and I tend to do like Isabel just did then. I've been told before that when someone's asking a question, I nod along and I go, and I don't realize I'm doing it, but everyone can hear me doing it. And so that's something I'm trying to avoid now. But yeah, it's honestly, it's not too major as long as it's still clear, but that all just is the fine tuning of speaking.
Right. I think we've just had a question come in from Kevin.
When you say the criminal law moot, this isn't John Hague, is this the sentencing one in criminal law? Is the moot this year in criminal law a sentencing one?
I think it's always a sentencing one.
Yeah.
The criminal law paper.
We were the same. The year we did it, we didn't get to do it. So then I went and did the comp because I was like, I want to learn what sentencing is.
I think
John
John
Haig.
Haig.
Okay.
So with appellate cases, particularly criminal, it generally is about law, but also appellate evidence cases are also about the facts.
Yeah.
So in an unhelpful way, you'll need to do both.
It really
But
depends
I don't
on
know
the
the question,
question.
so it would depend,
Yeah.
but I'd say probably it's
law to the
both.
facts of the case. It really just depends on what your issue is and what you're arguing. And it might be that you're arguing a point of law, but it's obviously in the context of the facts that you have at hand. And so you can't remove it from that because that's what's relevant. Because if you're asking them to decide, I guess if you could think about it this way, if you're arguing a point of law or a question of law, what you're asking them to decide, and if the court decides on that point of law, will then have implications on the outcome of your case factually. Because if they decide a new approach or a new point of law, and then you apply that to your facts, that might mean a different outcome, which is how the facts are still related and linked into that. So you'll be arguing the question of law, but it's going to have repercussions on then how you apply it to these facts. And so that's how it's tied in, but it's really dependent on the question.
If you guys haven't got any other questions sitting in your chats,
we're good for now in terms of general ones that are applicable to everyone.
Do you have any specific ones? I think we're getting to the point where it's getting quite late and we should be wrapping things up. But if you have specific questions asked to you, or if anyone in the watching wants to ask a question now in the chat or wants to raise your hand, go for it.
Before we wrap up, I will just say the key for mooting is confidence, and you have to be persuasive, and you get that by doing the prep. There's no way around it. But if you do that, it's a really enjoyable experience, and you get to discuss with judges and top lawyers, and that's actually quite valuable. And you get feedback on your advocacy when you're in law school. So really make the most of it, and enjoy it.
Yeah, as terrifying as mooting and speaking can be, try and enjoy it as much as you can. And remember that just because you're not, maybe if you don't do public speaking or you don't like public speaking, doesn't mean that you're not going to like mooting, because mooting is quite different. It's in a very controlled environment. It's, all surrounding the law. And so that's quite a different context to just generally public speaking. So don't get put off it if you're not a public speaker or anything. And really try and enjoy it, embrace the questions. I mean, it's such a cool opportunity. You're going to get judged by some incredible judges. You'll get asked some hard questions. Some of them you won't be able to answer. Some of them you'll think, oh yes, I've prepared, I've thought about this, I know the perfect answer, and it'll be so satisfying and rewarding. So, you've got to take a moot with its ups and downs. Every time we've finished a moot, it's really easy to focus on the little things. I wish I had said that, or I didn't do that right. But overall, it's a pretty impressive thing, anyone standing up and doing a moot and getting questioned on the spot. It's not easy. So definitely give yourself credit for doing it.
Yeah, and I'll just also impart some words of motivation. Although Andrew can attest to how much of a hypocrite I am going to be saying those words. Don't beat yourself up too much over any sort of result or what you could have done better. Mooting is while obviously you should be trying your best, some of mooting is quite dependent on luck. Like different judges like quite different things sometimes, and also depends on like who you're up against in your little group of people that the judge is assigned to, and all these little things. So I think just kind of try to take away from the experience all of these things that you did, the fact that you stood up and answered questions, and hopefully like that should be your main motivation for mooting. So hopefully no matter what, you'll just kind of continue to moot, because it is just really good to do just as an exercise.
We have a few specific questions. one last one is sort of in a way in line of what we just said, but just generally in terms of our journeys at law school and getting, marks that maybe we weren't so happy with, and what made us sort of keep going, and, were there any moments at law school where we were like, why the hell are we doing this? So definitely, I mean, for me, and I don't know, a lot can relate, COVID was a really hard time. I really struggled online learning. It was the first time I ever got behind in lectures, and I had a heart attack about every day because of it. It was terrifyingly new and scary for me doing learning like that. And so that was definitely a tough time. I look back, I sort of get trauma shivers. But then there are just these moments of law school when you do kind of remember why you're there and why you enjoy it. And for me, and Mooting was a huge part of that. Mooting was the part of law school that I loved without a fail. And so I always just had that to look forward to. Or it was, even just sometimes, law school can get a lot better in the sense of when you're doing electives, you can actually interact with your lecturers more maybe, and you're learning about more niche areas that you can engage with more. So there are definitely really cool moments throughout law school, and hopefully now with everyone coming back on campus, it'll be a lot better experience as well. That definitely keeps you going. But I think it's really important for you to find your own things as well. Like for me, Mooting was a huge part of it. It doesn't have to be that for you as well. It's finding aspects of law school that are interesting to you, whether it's doing extra reading on stuff that you're interested in, actually interested in, or writing some ideas of your own. If you feel a passion for something and you actually want to write, and go and find the lecturers in that topic and in that area of law, and maybe go and chat with them, and just engage in an interesting discussion that isn't for an exam, isn't for an assignment, isn't to try and understand, something that's going to be assessed, but just for the pure sake of learning. That's my big thing.
Yeah, I completely agree. And I'll just add two things. First, if you talk to most successful judges, lawyers, people that have done a law degree, there'll be some grades they're not proud of. That has not stopped them in any way from having amazing careers. So don't have to worry about that. Even though at the time you're just like, oh no. Secondly, is that law school is a very artificial environment where you have to cover every single area of law, and you have to do it for 5 years. And by the end of it, you just want to get out and you want to start working. And so I think, keep that in mind. You may only find one area of law that you like, but that means when you leave law school, that's the only area of law you ever have to encounter ever again.
Yeah.
And so sometimes when you're like, oh my gosh, this is so hard, why am I doing this? It's important to keep, even just that one area. Like, for example, I like tax and animal law. They don't combine, but I like it too. And so sometimes, if things are hard, you're like, oh, I'm really looking forward to a career doing this. And so it's just keeping that in mind, that law school is artificial, the way you have to cover everything. And that's not going to be, the rest of your career, which is going to be so much longer and more fun than law school. Hopefully. And a final thing is, sometimes it really helps when you're lacking, when you've had a disappointing grade, or you're finding your courses really hard, is to reach out to a lawyer who's perhaps working in an area you might want to work in, and just ask if they're free for a coffee, because that can be really motivating to talk to someone who's doing something you might see yourself wanting to do. And that can be a great way to put it in perspective and to sort of reignite that spark you once had for law. But I think everyone goes through those times. Law school's hard. It can be really isolating, stressful. So yeah, just remember that you're not alone. Everyone goes through that too. And
yeah, as much as I can say I loved law school and love law, there were definitely times where I was like, oh my god, like I'm so done with this. So yeah.
I don't have much to add. I am still suffering through law school myself. But yeah, I think listening to people who's kind of come out on the other side, has kind of sees the bigger picture, is quite helpful. And just I try to keep in mind why I'm doing this in the first place. Trying to find things that interest you within this broader law faculty. And don't worry, I'm definitely still going through it, but those are just some things that I found useful.
Yeah, I mean, we're still writing our honors dissertations while working, so we're still suffering a little bit. But yeah, it's just same as what Isabel had said. There was a moment in my dissertation where I went and chatted to someone that was in relation to something I was looking at in my dis, and it was the coolest chat ever. went beyond what we were necessarily going to talk about for my dis, and it was just such a cool experience, and it reminded me of, that's a really cool positive to take out of it. And so yeah, I also think we had a question regarding first year moot topics and any general patterns. I mean, if you look, you'll see that pretty much every year it's been privacy. Obviously don't know if that's going to happen again or not. It really depends, but I wouldn't go too much onto what the previous topics have been or anything, because often even within one topic, the way that the issues addressed, the angle that's taken can be so different. And then I know we had a few specific questions on sentencing in particular earlier on, so sorry we didn't get to them. They're a bit hard for us to answer in the abstract, but I would just say if you're struggling on finding some things in terms of researching or preparing, try and, instead of getting overwhelmed, and especially when you've got a lot of things on your plate, draw it back down to, okay, what's one thing I want to figure out, and start there, and then start adding layers in your research, because sometimes you need to strip it back and start with one point that might find you and then lead you in other places. And then, sorry, this is one more thing that I remembered back to when we were discussing just getting through law school, is have something outside of law school. I cannot stress how important that is, to have something else that you also really enjoy going to, or you look forward to, or as a stress release that isn't related to law. Because I mean, as much as I love law and, it becomes my life 99% of the time, I do need that little bit outside of law that just sort of grounds you. And, one of the best things to ground yourself is to talk to people who aren't doing law, and all your stresses and all the things that feel really overwhelming and all the things that's really easy to discuss with everyone else who's at law school doing it with you is completely irrelevant to them, and they don't care. So sometimes that's the best grounding ever. Don't know if anyone has any other questions. And
I
if
did
anyone,
get quite a practical question come through about clothing the moots. Clothing requirements. Do you have what should you wear? Do you have any tips on that?
I mean, the most safe option is just the black blazer, black pants, and white top. You can't really go wrong with that. But I think just business, usually just business attire in general.
as professional as you can be.
Yeah.
I mean, we totally appreciate that it's difficult, to get attire like that, especially if it's your first moot. And when we were doing the first year moot, I wore my mum's pants safety pinned because I didn't have a pair of formal pants that weren't jeans. So we all start somewhere in terms of clothing, and then I finally got a proper suit. But as formal as you can be, because it's courtroom attire, which is professional. And yeah, the standard is the white top, the black, but we've also worn navy suits. You can wear other stuff. What you really just want to look is presentable, and you don't want it to detract from you or your argument. But yeah.
I think now the Mooting Society has a great new wardrobe as well. So it's not something to stress about. And I'm sure they will always be available to answer any questions you have if you're concerned about that.
Yeah.
So don't stress alone, reach out and they'll help.
Yeah, it won't make or break you progressing in a moot, or at least it shouldn't.
Right. Unless anyone at all has any other questions, and feel free to shout out if you do, I think that brings us to the end of the workshop. Hopefully you've all learned a lot from our wonderful panelists today, and I'd just like to thank them again for giving up their evening to be with us and impart their wisdom. But yeah, unless there are any last minute questions.
I will say that if anyone thinks of any other questions later on or anything, I'm sure for the others, but feel free to email or reach out to us or LinkedIn or ask the Mooting Society for our contacts if you think of any other questions later. And obviously it's difficult, the specific questions we can't always answer, but if it's general ones, we can.
LinkedIn, Facebook, email. Someone just asked for email address. Maybe perhaps Mooting Society. I'm happy for you to
email us, and we can pass on any questions you have to our panelists.
Yeah, thank you.
We love mooting, so fire questions
we're always happy to talk about it. And good luck to those who are doing the sentencing moot and the John Hague. Just really enjoy it. Really cool time.
Very much. Okay, thank you
All right.
guys very much.
Worries.
worries.
Have a good one.
You too.
Bye. Thanks for organizing.